your many blessings, for another opportunity to sit and deliberate on important matters affecting the health of our people in the nation. We ask for guidance afresh, for focused attention, and we pray that everything that we do be to your glory. In Jesus' name, amen.
Thank you very much. Okay, so let me just also mention that just remind us that it's a hybrid meeting. We have online Minister Malahoo Fort, you just heard her a short while ago, and Mr. MP Marlon Wilson, and of course we have two members here in the chamber. We have Senator Cherie Golden Campbell and Dr. Guy, Member Guy. So the quorum is 4, and we have 5 persons, including myself. I want to state for the record, our apologies for Senator Allen and up to this point, Senator Longmore, who may attend if she gets through an appointment in time. So Senator Allen and Senator Longmore. Want to use the opportunity to firstly welcome all who are here back to these discussions around the Tobacco Control Act 2020, and hope for all that you had a restful period during the summer break, that we all took a few days off. Of course, to the members of the committee, but very, very importantly to the supporting team, the technical team, who are quite consistent in terms of their arrival and their timeliness. I want to recognize all of you. Too many names to mention. I see Mr. Stein, however, from PAHO, so I want to recognize him and his team, who has been very supportive, but all the various groups representing the Solicitor General's office, the Parliament, and of course the Ministry of Health and Wellness. Thank you very much, and my best wishes for this term of work going into the Christmas season. All right, we're going to go straight into the minutes. We're hoping that we can complete the deliberations on these the act and get a final document, hopefully, to be tabled in the Parliament for debate during the course of this calendar year. So I'm hoping that we'll make some progress today. You may recall, by way of context, that we had suspended the last meeting to get some conversation going at the level of the ministry, and in particular, Mr. Edwards, who is our chief consultant on this deliberation, and the Solicitor General's office, and where necessary other stakeholder groups to complete and hopefully agree on some of the wording of aspects of the act. And so I'm hoping that will hasten the process as we are about to go through a number of critical areas. We intend to go through clauses 7, 8, 9, 15, 19, 24, 27, 38 and the second schedule. And then afterward that we will go back to clause 2 around interpretation. 7, 8, 9, 15, 19, 24, 27, and 38. And then the second schedule. My understanding is that this was all sent out to members, so all members should have copies. So 7, 8, 9, 15, 19, 24, 27, and 38. And then the second schedule. And then we go back to clause 2, interpretation. This is after we would have completed those particular areas. I want to also mention that, hi, how are you? That we did receive some correspondence during the course of the last month or so. Correspondence from Carreras Limited, expressing some concerns about the amendments to the bill, not reflected in the proposals, amendments that they recommended, and of course requesting a meeting to further discuss. Just want to mention it for the record. As far as I am aware, we did go through thoroughly all the recommendations that we received from the different entities where we thought it was necessary to deliberate. We deliberated. So,
you said we are going in the second schedule to 7, 8, 9.
No, we're starting 7, 8, 9, 15, 19, 24, 27, 38, and then the second schedule.
Okay.
Yeah, in that order.
Chairman, just to say that I too received correspondence from Carreras with their expression of concern and their request for a meeting to discuss the matter. It appears that there may not be a sufficient understanding that the health implications of the product really will have economic implications for the company and how business is done, because the very nature of the bill is to control and regulate the use and the sale of tobacco in our jurisdiction. So just indicating that I also received the correspondence with a request for meeting.
Yes, and I know others have. And listen, it's understandable that the entity that is likely to be most affected would seek to make their point and to defend their position, just as how we in public health and the rest of stakeholders have a right to do the same. So it's part of the deliberations. I'm just mentioning it for the record so that it appears not that we are ignoring any concerns raised. But you're correct. I mean, this is a bill, an act, a law to be that is likely to impact the operations of the entity, and we believe with justification. But their letter is noted, and just for the record, we did go through all the proposals that were placed on the table. I also want to mention that PAHO, the Pan American Health Organization, provided a number of documents which they had committed to providing, which were circulated also, evidence supporting an increase from 60 to 80% for graphic health warnings, along with studies to show the effectiveness and impact of increasing the size of same, information on tobacco advertising, promotion, and sponsorship and packaging, and application of Article 5.3, the engagement of public officials and government employees with the tobacco industry, and how tobacco companies influence sales through the provision of incentives and benefits to retailers. Again, those information should have been circulated at the last meeting, and those that were not circulated, I'm told, will be circulated today. They should be at your desk now. Okay, good. All right. So we have notices. Can we now move, if there are no comments, into the minutes of the meeting? Reading and confirmation. That's meeting held June 9th. And we all should have copies. Page 1 of 11. Page 2. Three. Pages 4. 5.
Chair?
Yes.
If I may, on page 2, just two observations. There's a reference to
Ms. Wilkins as the Director, Legal Reform Department.
I'm not hearing you well at all.
Sorry, members and colleagues. Yes, there's a reference on page 2 to Ms. Nadine Wilkins as Director, Legal Reform Department, but I still understand that the role she plays is as Director of Legal Reform, not a director in the Legal Reform Department. It's Director of Legal Reform in the Legal Reform Department.
Where is that?
The second paragraph of on page 2.
Oh, I see. Okay.
Director of Legal Reform.
Okay.
And then in paragraph 5, under the heading number 5, welcome and opening remarks.
Yes.
The reference in the last sentence to Mr. Edwards will suggest the appropriate wording. That is so as far as it goes, but Chair and members, I must remind us of the process that even if the Ministry of Health, through me, does make those suggestions, it is with a view to the committee's agreement and the wider technical team settling the matter, because as we know, the Parliamentary Council, the AG's office are also involved in the process. So I just want to clarify that even if the health team makes suggestions as to wording and the committee agrees, there is the final sign-off by the drafters and other technocrats. Thank you.
Okay. All right, fair enough. Page 6. Seven. Eight. 9. 10. 'And finally, limited information here, page 11. Okay. So if there are no other comments on the minutes, can I ask for confirmation? Moved by
Chair.
Senator Olin and seconded by Senator Gale, and I want to welcome Senators Morris, Gale, and Wilson, who came in after we started. Huh? MP Wilson. Wow, taking away your hard-fought and hard-earned elections, right? Sorry about that. All right, any matters arising? We'd want to just go right into the clause-by-clause deliberations, but any issue that you want to raise before? No? All right, I'll take it that we are all going on to item 7, which is the continuation of the clause-by-clause analysis, looking at the outstanding matters. So, as said earlier, we want to begin and go through 7, 8, 9, 15, 19, 24, 27, 38. And so we'll start with item 7. Where's Mr. Edwards? All right, so we're going now to clause 7. Okay, so it's 7, 8, 9, 15, 19, 24, 27, 38, and then after, assuming we're complete, the second schedule. Mr. Edwards has the information, so I guess we have to await his arrival or return. So just for information purposes and context, the item 7 speaks to the policy of the government in relation to tobacco control, and speaks to the public health policy of the government, which relates to tobacco control, shall provide for the development and implementation of a national strategy for tobacco control, the protection of the public against the influence of and interference by commercial and other vested interests of the tobacco industry, and ensuring that there is transparent and documented interactions between government and the tobacco industry. Next, it speaks to, pursuant to subsection 1C, the minister shall ensure that all records and documents related to the interaction and communication between the government and the tobacco industry be made available to the public. And 3, subsection 2, shall not apply to any record or document which may be promotional in nature or prohibited from disclosure by virtue of any enactment. So that's the clause that we are examining. Still waiting on Mr. Edwards. Thank you, Mr. Edwards. Welcome back. Are you okay? Come. All right, Ms. Edwards, if you know, if you need to elaborate and address the issue, then let me know whenever.
Yes.
All right, but in the meantime.
Thank you.
All right, so let's proceed. So I just read through clause 7, which is the first of several clauses to be deliberated on. So I would like you to just lead us through, since some work should have been done prior to this meeting on that. What is being recommended.
Yes, Chair. So the issue, okay. So we have proposed a modification in the language of Clause 7. The original wording spoke to the public health policy of the government and what it should provide for. In the new language, in the proposed wording, we are now speaking to putting a direct obligation on the minister. Let me. Sorry, I'm not seeing it. Okay. I'm sorry, Chair. I'm trying to locate the adjustment that had been proposed. Chair, may we move to another provision and get back to 7, if possible?
Well, after 7, we have 8, 9, 15. Which
That's
ones
right.
you have in front of you?
Yes. So I think members would have before them the suggested text, and highlighted words are the words that are seeking to address the concerns of members.
Which one are you dealing with?
8, Clause 8, Chair.
8.
Clause
Okay.
8.
So limited interaction with the tobacco industry by persons who have responsibility for tobacco control. Subclause 1, an amendment should be made to the provision to make explicit the intent of the interaction of a person who acts for or for the benefit of a public body which has responsibility for tobacco control with a person in the tobacco industry. And then subclause 2, provision should be examined since it was unusual for legislation to indicate that documents must be transparent by mandating that they be in writing. So what did the consultation come up with?
Okay, so Chair, we have been in dialogue with our technical team, meaning the Attorney General's Office, the Office of the Parliamentary Counsel, the Legal Reform Department, and have received some very helpful suggestions, particularly through the Solicitor General and her team. And we have actually, what is now presented to the committee is a revision of the original language that was being proposed, because there was concern that we should have provisions that are, one, certain, that reflect the rule of law, that there's no arbitrariness in the language, especially because criminal penalties are the sanction. So we have sought, one, to tighten up the application of this provision. You notice it speaking to public official. There is a definition proposed for who a public official is. There is also a definition proposed as to what we mean by interactions. Fairly detailed definition. Interactions means meetings, correspondence, or other exchanges between a public official and a person in or representing the tobacco industry that arise when the public official meets with such a person.
Chairman,
or
where are those new definitions?
Yeah,
these are in the document that was circulated yesterday.
Yeah, but there's no definition here in my document of what a public official is. You're on a public space.
Yes,
in terms of the interpretation.
yes, it is. Sorry, the definition of public official appears under clause 9. It applies to both clauses 8 and 9. So it actually appears on page, I think it is page 6, under the definition of, under clause 9. It's under the heading related definitions. Those definitions govern both clauses 8 and 9.
It's they're not numbered, but look at clause 9 and then flip 2 pages over.
The definition of interactions is in clause 8 because it only applies to clause 8. So it's at the foot of clause 8 as subsection 4. And it's highlighted in yellow.
Chairman, if I may.
Go ahead.
I thank Ms. Edwards and the team. I think the question of which public official you're trying to capture in 8 is much better with the revised version. But I continue to have a difficulty with even this definition of interactions. I can't see how a public official with responsibility for tobacco control and all the meaning that is now attached in the revised version can be barred based on interactions when those interactions are so general, a meeting or other exchanges between a public official and a person in or representing the tobacco industry that arise when the public official meets with such a person or the person's affiliate in a business forum. We've narrowed it in the first part of the revision, and then we've gone scattershot again in this subclause 4, because what does other exchanges mean? What does, I mean, I can see quite easily that a member of Carreras and the Minister of Health could conceivably be in a meeting of just not necessarily related to tobacco control, but as a member of the cabinet in a meeting that business
Sure.
people attend.
Sure.
It just seems like we've gone in the opposite direction with that interactions definition.
Member Guy.
Chair, I hear my colleague, but I want to look at the other part of it. Shall not conduct interaction with a person, tobacco industry, in furtherance of a business activity, commercial enterprise involving the public official, the other person, the public body, or more of one, or one or more of such.
I think you can turn the mic back on.
And further, Chairman, it says, except where it is strictly so to do in order to ensure the effective regulation of tobacco industry, tobacco product, or relevant product. So I think my view is that they have captured what the discussion and the deliberations of the committee so far have been in protecting persons.
Yeah, I'm inclined to support that. I mean, you have to take the clause in its full context, and it's not suggesting that people can't be in a room who may be affiliated with a tobacco company, but the issue is what is it that is being discussed or advanced. So I think that is sufficient to capture more the substance of what we're trying, the injury that we're trying to prevent. Unless there is a view, I see where, is SG, you have a comment?
Thank you, Chair. So I just want to clarify for the record, the chambers did not sign off on the draft before you because we only got it. What we had commented on was the draft before. We haven't had an opportunity to send comments on this draft. And we got an explanatory note late yesterday afternoon. I have to say that I still cannot see how we can support what's in Clause 8 being a criminal offense. And the explanation that was provided to us, to me, is not sufficient because we were pointed to the guidelines on the framework agreement, and there's nothing in those guidelines, and note they are guidelines. There's nothing in the convention that requires criminalizing this. There's also nothing in the guidelines that even suggests that you should criminalize this activity. Again, my position has always been these activities basically are conflict of interest and related matters. We don't criminalize that in our jurisdiction. Some of it does go to corruption, and we have corruption laws. So I still cannot see how we're going to go to this leap to criminalize this activity. And looking at the definition of interactions, I am troubled about what the committee is still considering as interactions. I do know that it has been narrowed significantly from what was presented before. So it no longer seems to address more personal activity. But again, as it relates to when you try to now criminalize, and I keep going back to that because rule of law dictates how certain you must be when you're going to be engaging in criminal activity. I know that a good defense lawyer could poke holes in this kind of framework, let me put it this way. So we still, from the chambers, the AG's chambers, we still have concerns about this clause.
Chairman?
Yeah, go ahead.
SG, sorry. What about Clause 8.1? I know that in terms of your statement that you have not really had the opportunity to go into it, but just a cursory reading, would that cover what the committee would desire without breaching any of the laws that you have outlined just now? We're not talking about the criminalization of it
right.
or anything.
So Clause 1 is basically, I'm not even sure what Clause 1, to be honest, even though I was given an explanatory note. So my question to you would be, who are these individuals that direct or influence policy? Now, the persons who direct policy are cabinet. It's cabinet members. Persons who influence policy, to be honest, I'm not clear on who that would be. Which person do you think influences policy? What do you mean by influence policy?
That would be everybody in this room.
But
well, I would want to take myself out of that because I'm a legal advisor. I don't know that. You see, that's the thing. I could argue that even though, for instance, I can comment on a cabinet submission, I'm doing it from a legal perspective. Are you saying that my legal comments can be used to, could fall under this thing of influencing policy, I don't think it's clear.
Well,
I don't know who it is.
Chair.
Chairman, since I opened it, can I be allowed to? So I think the committee's concern, as we have been over the past couple of weeks, months, is where would you put that individual who has direct responsibility for oversight of the tobacco in the Ministry of Health then? Say a technocrat who has been given the responsibility for having oversight of this piece of the legislation to ensure that it is followed to the T, and then that particular individual goes and have an association that we would not want, based on what is in the provisions here, to have, say, a business arrangement with someone who is in the tobacco industry. Where would you capture that particular individual here as we have at just Clause 8? Because we know about the parliamentarians, we know about the minister, right, and all the rest of the others as being part of the public official here.
So if you're talking about a civil servant, it seems to me, based on what you just said, we could be looking at two different things: an act of corruption or a conflict of interest situation. I can't see it falling outside of the other two, but I could be wrong. So if it's outside of that, then you would have to advise me. If it's an act of corruption, I've already spoken about that. Those are covered, addressed in other pieces of legislation, and those pieces of legislation don't fall under the remit of the Ministry of Health and Wellness, except to say that the Integrity Commission Act is before a joint select committee of Parliament being reviewed. So if it is that the Ministry of Health feels that the Integrity Commission Act is not robust and needs some further adjustment to capture acts of corruption that are not in it, there is that opportunity to make representation to that joint select committee. Outside of acts of corruption, again, we're looking at conflict of interest. Conflict of interest can be addressed either through existing mechanisms that apply now to civil servants, and those would be the different, whether the public service regulations and attendant guidelines and protocols that apply now to civil servants, or the Ministry of Health and Wellness could also put in its own code of conduct, perhaps. And then maybe that is something that you would want to legislate for in this law, meaning through regulations. You could put in some sort of code of conduct, and you could try and give it, not try, you could give it force of law, because that has been done under the Public Bodies Management and Accountability Act, where they have given a code of conduct under that act, force of law. And so you could approach it from that perspective. Again, though, it is not typical that we criminalize matters such as conflict of interest.
Okay, can I just come in here? Because I can't say I'm not a little disappointed in what is playing out here, because while I appreciate the deliberations which ought to take place to ventilate all the issues at this level, even before we get to the actual clause, I did make a request 2 months ago when we had our last meeting on the 7th of July, it was? June? 9th of June. Today is the 30th of August. Based on just trying to achieve some levels of efficiency, that the government agencies speak to each other on the controversial clauses. And I am a little surprised that that directive seems not to have followed through sufficiently, where we're now engaging in a conversation around a clause, not so much by the members of the committee, but by the government agencies, the SG in this case, and the ministry. So that disappoints me, because I did get a signal that some conversation took place. I was hoping that where an agreement couldn't be arrived at after the consultation, then it be brought here, and then we deliberate on that, and I'd fully appreciate that. But it appears that those deliberations are incomplete, given that you say you just received that information. what I'm going to propose is that we go through the clauses that are not controversial and where maybe some kind of dialogue took place, and then we go back to the ones that clearly you have an issue with, SG, and see if we can deal with those here, or we need to break until the next meeting where some kind of discussion takes place. I hear your point about the conflict of interest issue and the corruption issue, and those are valid points. So I'm not dismissing them. I'm just saying that I was hoping that a process would have been followed, which clearly has not been, which is a disappointment. We have to move on this, and we can't drag it out beyond, you know. So, Mr. Edwards, you want to move on to the, I don't know if you have a, I don't know if it makes sense to have a comment on this, because maybe we should go to the ones that are not as controversial. Yes, SG.
Excuse me, though, Chair, just to say that what has been presented by the Ministry of Health and Wellness is emanating from the committee. So I'm not sure that we can resolve these issues on our own, because
no, you can't.
These are right. So this is why I'm saying, even when Mr. Edwards will present something, what he's presenting is a form of words to give effect to what the committee has asked for.
I hear you, and I'm not asking you to do the work of the committee. What I wanted, hopefully, was some consensus around where there is agreement and where there isn't. The committee still reserves the right and has the authority in law to make the decisions, and I'm not trying to burden you with the decision-making process. But some of these issues, I think, are better served if there is some conversation between the legal minds. That's all I'm asking. I'm not a legal mind. I don't know. I need to be advised. We need to be advised on the precedent where it exists. For example, you're raising an issue now around criminalizing individuals under this clause. You know, I would benefit a lot as a non-legal mind from someone explaining to me what happens in other jurisdictions. So, you know, that's something that I think easily both agencies could have sat down and consulted on and said, listen, there's nowhere in legislation anywhere in the world that this happens, or there are 5 countries where it happens. And then it comes to the committee and say, listen, it's an unusual position, but it is possible. It happens elsewhere, or it never happened before. Then we can make a more informed position. But not to come and to argue it in a way that appears as if there's no discussion taking place. To me, it's a little untidy based on the directives that have been given. So I would like to bring some more efficiency to the process. So,
Chairman?
Sure.
Yes.
I hear you, but I'm also going to say that even if it happens in other jurisdictions, the laws in other jurisdictions might not be the same as ours, and there are certain protections under our law which might prevent what the SG is suggesting, that we are going down down a road which would not be part of what our law allows. So I would agree with you to a point about what happens in other jurisdictions, and then to say, is there any way that we could morph that into our legislation?
I hear you. I'm not suggesting that that's the road we would take. Understand me? I'm saying we need to be advised, because the very advice you're giving could be the next piece of advice, having outlined that what happens in other jurisdictions. Anyway, you want to make a comment on that?
Because I agree with what you're saying. What is being proposed in the legislation is a particular clause that Chair is seeking to restrict behavior, in my mind. And when I look at the minutes of the last meeting, I saw where SG would have raised these particular concerns in a similar fashion to which she is raising today. And I can understand why, because we don't want to make laws that create unnecessary harm on the population. And what I was looking for as a committee member is where opinions could be provided by the legal team in terms of how we could treat this particular clause. And even if it requires us looking at what other jurisdictions would have sought to apply in this particular scenario that would be helpful. And also, you know, the question of what other legislation do we have that can apply in this scenario? And that's what I'm looking for as guidance as a committee member.
Sure.
So can I just say for the record, the chambers, the AG's chambers did provide a legal opinion dated July 13 on the revised draft. We then got a new draft on Sunday. Not been able to send comments on the new draft because, in fact, there was an explanatory letter sent yesterday with cases, which we have asked for, and we've just been provided with the cases. We're looking through the cases. Some of the cases are in excess of 300 and odd pages. We've not been able to review that clearly in less than 24 hours. But we did provide a legal opinion July 13 on the last draft.
Okay, so let me try and get us back on track here, and then we can solve the outstanding issues that have to be delayed. Are there any of the clauses that I outlined earlier that are fairly straightforward, sufficient not to be controversial? Mr. Edwards, based on what you have seen from the SG's office?
I think, Chair, this is the only one that I can recall is of particular concern, subject to the fact that, as SG said, there would not have been the ideal time frame within which she and her team would have wanted to deliberate.
So can we just move on then to the ones that are, you can take us through?
Yes.
Mr. Chairman?
Yes.
Can I just make one final point, since the team is going to take a look at this? Because in this said Clause 8, I still have a concern myself, notwithstanding what the SG said in relation to criminalization, but in the use of the clause, interactions with a person in the tobacco industry. Because when you look at the definition of tobacco industry, meaning tobacco manufacturers, wholesale distributors, importers, and exporters, when you say a person in the tobacco industry, are you referring to an owner of an entity like that, or you're referring to someone who works in that entity? I would ask you just to consider that in your deliberations. Thank you.
Okay, so we make a note of that and deal with that at that point in time. So Clause 9, prohibition on partnerships and endorsement of the tobacco industry, acceptance of voluntary contribution, etc. Technical team to provide amendment by considering that the clause shall be clear on any potential conflicts of interest and the avoidance of same, and that penalties be applied to public officials and public officers for any breach based on their role in the public body or in influencing tobacco control policies. Strong signal should be sent to other public officers regarding their participation in any activity regarding tobacco industry, and that the provision should be applicable to elected officials along with the appropriate penalty for any breach of the provisions. Further examination should be done regarding the chase fund, since the committee runs the risk of duplicating what already exists. All right. Was there any conversation around that particular clause, Mr. Edwards and SG?
So, Chair, again, noting some of the new provisions that were highlighted, we have some concerns. We have major concerns with the new 5. I don't think that has a place in law at all.
The new what?
5, the public official shall also be liable to have the person in charge of the public body that the public official is employed to, contracted to, or otherwise serves within, refer the matter to the relevant disciplinary body to which a public official is subject. For a public official can't require a permanent secretary per se to take certain kind of action, because that would be left to the permanent secretary. The public official can't be the one to direct that head of entity. So I can't see how this could apply in all the situations noting the meaning of public official, noting the meaning of public body, which would include central government. So yes, we do have some concerns with Clause 9. And you mentioned the Chase Fund, which would implicate Clause 6, and there would be a concern regarding that provision as well. With Clause 6,
what's the concern really, Chase Fund?
Okay, so you will recall that a few years ago, Parliament amended a number of laws, including the Betting, Gaming, Lotteries Act, which was brought to attention by Mr. Edwards because we had made some suggestions in our July 13 correspondence. The amendments made by Parliament, part of the fiscal responsibility framework, was to get rid of all these independent funds and pull everything into the consolidated fund. And I have checked with the Ministry of Finance and the Public Service, and that is still the policy of the government, where you don't have separate funds. Everything is now controlled by the consolidated fund. Ministries make requests for budget allocations, and it is dealt with through that process. So there was a proposal, for instance.
Mr. Edwards, oh, sorry, you weren't finished.
Right, so there was a proposal, for instance, to look at what is done in Kenya. The problem is that we have in Jamaica a very specific policy framework that would not then accommodate the establishment of a separate fund. And as it relates to the Chase Fund, that now is part of the consolidated fund. That was the amendment that was made.
All right, so it appears...
But
yes,
Chair,
Mr. Edwards, go ahead.
But we are ad idem with Solicitor General on that. We are not proposing... That's why the note is there in the list saying that we can't use Chase Fund because of the changes that were made. And Kenya is really just proposed because it is another jurisdiction that has tobacco control, recent tobacco control legislation, and that is a route that they took. But we closed that point by saying it is subject to the fiscal space permitting the operation of such a fund. So we do recognize that the policy in Jamaica is not to embrace such funds at this time. But we thought it would be useful at least for the committee to know the type of arrangement that could happen.
Right. Point taken. What about the previous point, the point around the public officials that was raised? In relation... On the same clause, yes.
No, that's a different provision, Chair. That's it.
No.
That's not relating to Chase Fund. That's a...
No. Prior to that, the SG raised the point on the disciplinary right around the public officials.
Yeah, that is tied up to the whole issue of conflict of interest and what we call the prohibition on partnerships and endorsements. And we do appreciate the opinion of the SG in that regard, but we also want to note for the record, Chair, that this provision, in fact, both clauses 8 and 9, yes, they have been recent, revisions of the language, and the Solicitor General and her team would not have had the ideal time to respond. But what we are seeing today is significantly different from what was previously presented. For example, in relation to Clause 9, 1, there is no longer any criminal penalty. Clause 9 is speaking to sanctions arising from breaching guidelines. So we're seeking to be more faithful to the provisions of the FCTC in that the disciplinary action would be in relation to contravention of code of conduct that would have been made governing the activities between public officials and industry in relation to Clause 9. So there is 1, no criminal penalty in that regard, and 2, provision is being made for the sanction being one that would be arising from breaching code of conduct. So we just wanted to point that out. Chair.
SG, was your concern or the concern from your office based on an assumption of criminal sanction?
No, I did not assume that because it's not in the draft. But the point is, the bigger issue is, how can a public official be liable to ensure that the head refers a matter to a disciplinary body? If you're talking about central government, that flies in the face of the power given to a permanent secretary, which is a constitutional power. And okay, if we want to say it didn't apply, you want to distinguish those entities governed by the Constitution and those that are not, I still think it would be a very strange situation where you have a public official who could be anybody in an entity being able to direct how the head of entity acts or performs.
What probably could be replaced here is some sort of protocol of how and what triggers a particular investigation or a particular course of action.
Correct, or just a referral. So
there
are other acts like INDECOM where matters, there is a duty to refer a matter to a head, but not to direct how that head is going to perform the functions.
Is it therefore a matter of just rewording the clause to reflect some sort of trigger for action to be taken, Mr. Edwards, as opposed to a directive, if you will, that could bring lines of authority into a sort of conflicting situation? I mean, is that what I'm hearing, SG? That maybe the clause could be rearranged to create a sort of trigger based on a particular protocol. So it's not a directive. It really is a mandate to act a particular way based on a breach that may have occurred.
Chair, before SG responds to that, I'm grappling with these clauses, I must tell you. And I'm going to offer this, which I think is the basis of what I'm grappling with. Whenever there is on a public board or an entity, a public entity, the question of conflict of interest is treated by disclosure of a potential conflict or an actual conflict. Once disclosure has been made and it is accepted, or the person recuses themselves from participation in the particular decision on the table, they have done what they are required to do, and there is nothing further. The problem I'm having with these clauses, I believe, is that we're trying to deal with a potential conflict of interest by saying that we are going to provide, in the case of 8, criminal sanctions, or in the case of 9, disciplinary sanctions, in the event that a public official finds themselves in a circumstance of potential conflict, not actual, potential. And so the remedy for that is disclosure. Now, I can't understand either disciplinary sanctions or criminal sanctions where the public official has not been shown to engage the conflict of interest to do something corrupt or in furtherance of the development of the tobacco industry in an unfair and unethical, or whatever the language is that you use when those relationships come too close for comfort. I can't understand how we're going to sanction somebody
when all we're talking about is a potential.
I hear you. But my understanding is that the clauses have to be taken as a whole, and that it speaks to not just public officials or interfacing with the industry, but interfacing with the industry based on a particular intent. Otherwise, I agree with you. If that is not clear, that ought to be clear, because one could engage in entrapment to create mischief if that intent is not specifically outlined. Beyond that, however, I am assuming that there is a due process, so persons are not considered guilty until that due process takes place. And that should also be quite clear. In other words, it can't just be guilty by association. It has to be based on a process.
But Chair, I don't think that's clear.
To establish intent.
I don't think that's clear in the
Well,
clauses.
if it's not clear, it needs to be clear. Otherwise, we would be doing a disservice to our role here. So, Mr. Edwards, over to you again, and SG in terms of clarity to ensure that intent is established and due process is allowed for. I don't know how you can get out of that. That should apply to every situation.
Yeah, Chair, what I'm going to say now is that there are jurisdictions where these types of provisions, Clause 8 and 9, don't appear in the primary legislation. What is happening is that we are working with a bill that has already been structured in a certain way. Because you notice we're speaking about a code of conduct. That's a whole regime that we are speaking of that would have to be developed subsidiary to what we're seeing on the face of these 4 or 5 subsections here. So we're not speaking about liability or determining who is guilty or what here. This is really just initiating a framework that will be developed and applied in detail in subsidiary legislation, in rules or code of conduct. So this is really just a basic framework indicating what the message to be sent if certain behavior takes place.
Yeah, this is not. But I think I come into your member, but irrespective, I think we have to have clarity. Otherwise, we run into all sorts of confusion. And this is the place to get that clarity. And if members are uncertain, and they're applying a certain level of thought to this process, can you imagine what would happen out in the street otherwise? So we have to make sure that there is an abundance of clarity. And this explains my little disappointment that your office and the SG's office has not consulted, not so much on telling us what to do, but on helping us to establish that clarity and at least giving us some options. So let me hear from Member Guy, and if there is no resolution to this between you two agencies, that is, we may just need to move on to the next clause. And maybe I have to ask the question of the SG, which of the, because she seems to have gone through everything, even though she got it at a late date, because she has done some consultation with the Ministry of Finance and so on. Maybe she needs to tell us which of the 8 or 9 clauses that we're going through she has found favor with from a legal standpoint, that is. And so we just go straight to those and get those out of the way. But let me hear Member Guy.
Chairman, thank you. Chairman, quite frankly, I find myself in a serious discomfort with what Mr. Edwards just said a while ago. We are developing a legislation that is going to indicate our intent, what subsidiary legislation will have to be done to deal with certain rules and so. If we are going to pass this as the bill, Chairman, and it's going to be enacted into law as it stands without these other provisions, and as you have clearly said, clarity, it is going to indicate to John public out there that we are doing a disservice to the people. And I would want to think that if we are going to do something that has a going to have an overall effect, that whatever subsidiary legislation that is going to come, that is going to give teeth to these legislations, should be part of what we deal with now from day one before we get into it, right? I cannot accept that we are going to be doing something that may mean somewhere down the road that we are going to have to amend some of these clauses in the very near future, because what this has done is to create situations which are not accounted for in the mainstream of law in Jamaica. Unless I can get another explanation to that, but I am still uncomfortable.
Okay.
Yes, so
I think we, okay. Can we move on then? Any other, Madam SG, are there any of the clauses that you have gotten some response on that you think are not problematic, or problems are minor, sufficient to a decision to be taken without further in-depth consultation?
Chair, I only focused on clauses 6, 8, and 9 because those are the ones that we had commented on before, and those were the ones that we had problems with.
Okay, thank you. So can we move on then to the next one, which is 15. Mr. Edwards, you want to take us through 15, please? Right. 15 speaks to protection of children. Technical team is to review the Child Care and Protection Act regarding the recommendation for the Ministry of Education and Youth on indirect and direct access to smoking apparatus and other recommendations in relation to children from the said ministry. Mr. Edwards?
Sure, we did not have any proposed changes to make to clause 15.
Okay, members, any comments? Or can we accept that we will accept this wording? You want to just quickly? Yes. Go ahead, Ms. Wilkins.
From legal reform.
Turn your mic on for me. Oh, it's on. Bring it closer to your, yeah.
Yes.
And maybe the mask if you so.
If the proposed amendment to clause 2 for the definition of relevant product, if that is accepted, then subclause 2 of 15 would not be necessary, because the proposal in the document circulated by Mr. Edwards is for an electronic non-nicotine device to be part of the definition of relevant product.
Are we accepting that?
So you would need to break out tobacco product or relevant product in one, and then deal with electronic non-nicotine delivery system you'd integrate them in one, because relevant product includes the ends.
Mr. Edwards, or members, any?
That is a consequence of the proposed definition. Yes, Chair.
Oh.
None what? Just.
Mr. Edwards, can you remind me, what is a non-nicotine delivery system?
What we call the ends is
that the same as the
vape?
The vaping?
Vape.
Okay,
but
okay.
Just that it doesn't have nicotine.
Okay.
Mm-hmm. You have those that have nicotine. You have the nicotine devices and the non-nicotine devices.
Thank you.
Okay, so if we are in agreement with that, can we then accept 15 and move on to 16 to
Chairman,
8?
before
Yes.
you go, I crave your indulgence, and I'd like to go back to one of the controversial clauses that we have.
But can we? Is it
Chair,
on the same?
No, it is important.
Okay.
It speaks to public official, and we recognize the parliament here and that. But why the security forces, and we have gone to the subsets, the Jamaica Constabulary Force, the Jamaica Defense Force, and the Rural Police? Why have we included them as part of the public officials here, Mr. Edwards?
Sorry, 1 second. I just want to sign off on 15, unless it's related, and then you can go back to what.
All right. Okay.
So, all right, because we're trying to get some, So are we agreeing then that we move on?
For 15, since the Director of Legal Reform had pointed out the consequential amendment, well, that 15.2 would need to be deleted, 15.4 would have to be adjusted. So I'm just pointing out the consequential amendments for 15 for the committee to also agree on that when you're taking the decision.
Mr. Edwards, you want to just take us through? Let's just finish 15, please, and then I come back to you, Member Guy.
These are arising because of the proposed change in the definition of relevant product to include electronic non-nicotine delivery systems, so that, as the Director of Legal Reform has pointed out, subsection 2, once that definition is accepted, the proposed definition of relevant product to include electronic non-nicotine, then subsection 2 will no longer be necessary because subsection 1 will incorporate that concept. And similarly, as SG has indicated, if that definition of relevant product is accepted, then subsection 4 would no longer have to refer to 3 subsections, but just 2 subsections.
That's accepted.
And then subsection 5 would also have to be consequentially modified because there would be no need to have subsections 1 and 2. Yeah. But the thing is, Chair, what I need to point out, if I may, is that we will have to go through, once the committee agrees to modify the definition of relevant product, we will have to go through the whole bill anyway to ensure that there are no other consequential changes that need to be made once that definition is accepted.
Yes, but at the same time, I do intend to go over the bill 100 times, and that's the challenge I face. We have to be sufficiently comprehensive as we kind of walk on through, because I think we run the risk of keep going, and not ending up anywhere. So we have to be mindful of the changes while we try to appreciate the context and what it means. But thank you for that. So are we comfortable then? SG, you're okay with 15? We can say then we have achieved something tangible today so far. If you try hard enough, you'll get there, right? So let's go on now to 6.
Chair, before you move from 15, can I
you're disappointing me now.
No, I want to just red flag it because I'm not clear that we have an answer to the concerns that were expressed by education in relation to how children are treated in terms of the access, direct and indirect access. So if the team could still let us have that information, because they had a whole submission about different concerns. I think they're an important stakeholder.
But what aspect of it you're not sure about?
I'm saying the last time the committee decision was that the technical team should review the Child Care and Protection Act regarding MOE's recommendation on indirect and direct access to smoking apparatus. I'm not recalling the particular point, and I was just trying to run through their submission to find the reference, which I may raise again at the end. But I'm just saying we have not had a response to that.
Okay. All right, so team, just bear that in mind, and let us try to do some follow-up. Mr. Edwards, Ms. Birch, and you note that for us and assist in terms of the follow-up, yes. Does it mean that we're not accepting 15 until that clarity is brought? Is that what we're suggesting?
I'm not saying that, Chair.
Okay,
I'm prepared to support it in its current form, subject to some further advice that would move us.
All right, so let's aim for the next meeting to bring some clarity to that particular, to the questions raised. All right, 16 to 18.
Had suggested.
Member Guy, you wanted to raise an issue. Which clause are you referring to?
I want to go back to related definitions of public officials, and
that's the controversial clause.
Yes, but
we had agreed that we would.
No, Chairman, and I do agree with you that we need to go back.
Okay.
Send it back, but I want to know now, why is it that the security forces are included as part of the public officials? Rural police, what they have to do with this whole thing? the Jamaica Defense Force. I understand the Jamaica Constabulary Force that they might be involved with enforcement of certain things, but why the others?
If I may, Chair, this will be consistent with looking at the whole issue of governance and anti-corruption. And if we're going to be consistent with legislation such as the Integrity Commission Act, the scope of public official would include members of the security forces. So the Ministry of Health did not see a reason for excluding that category of person who serves in the public service from the scope of public official. We would have had to be convinced why we should exclude any particular group of public sector workers from this definition.
So why don't we put Indicom in it too? Why don't we put the municipal police in it too? You know, that's the point I'm making. And if we can find any other law enforcement entities.
But municipal police do perform a public function. There's a broad category there of a person who doesn't fall within A, but who is employed to a public body or performs a public function.
Yes.
So
yes.
members of the municipal police or Indicom do perform a public function. So they would fall within that category.
Okay. So the municipal police, they're not members of the security forces then considered, no?
We don't normally identify the municipal police when we're referring to the security forces.
All right. So can we member guy, can we lodge the concern so that the follow-up deliberations can consider? So just bear that in mind, Mr. Edwards.
Chair, can I just make a comment on that? Because I'm not so disturbed about the public official definition, including these different bodies, because what I expect is that every provision of the bill that directs a sanction at a public official will be narrowed to a public official who is influencing, directing, or controlling tobacco policy. So if that is done, then the definition is not disturbing.
It's appropriate.
To me.
Yeah. So let's add that to the consideration, please. And I really am encouraging copious notes taking so that we do not revisit these issues at our next meeting. And I know that SG is very good at taking notes, so she will make a note of these things, right? I can't see you smile because you have on your mask, but I know you're smiling with me. Let's go to 16 to 18. There's no amendments were recommended for the clauses. Any objections to that or concerns around that, 16 to 18? SG, you had any time or a chance to look at that? Are those clauses?
Sorry, Chair, these were clauses that the committee had gone through before and we had given comments before. So I think the only ones we would have now focused would be those on the proposed amendment sheet.
Okay.
So we wouldn't,
so you're
be
comfortable?
Objecting to, right. I think it would be like, I don't know if legal reform may have.
Fair enough. I like to hear that. It shows collaboration, which is so essential. Member Guy, you had a comment? You yield on that. Okay. So can we move on and accept then those two, 16 to 18, well, 16, 17, 18. And then we go to clause 19, prohibition on sale of tobacco products or relevant products in certain places. Speaks to the term public places should be redefined in clause 2 to provide for a clearer interpretation. Similar to the Criminal Justice Suppression of Criminal Organizations Amendment Act 2021, which provides a harsher penalty when a child is recruited to become a part of a criminal group. This recruitment is done within a certain distance of an education institution. provision should be made in the bill for a similar offense when there is continuous intentional or negligent exposure of children to the sale of tobacco products and relevant products. What say you to that, Mr. Edwards? I have a very strong opinion on this, but let me hear you first. Essentially, we're benchmarking against another piece of legislation based on the exposure to minors. What is your comment?
Chair, with respect, I'm not quite following where we are now, because we had gone through the list of decisions that the committee had made, and the proposed amendments were based on that list coming from the committee deliberations. So the second schedule, what we did was modify it, or propose modification to exclude public place, because that was a concern that the definition in the second schedule was too broad and unclear. Mm-hmm. And that was the issue that was being raised by a number of persons who brought concerns to the committee, that the definition of in the second schedule was too wide, because it included a reference to public place. So we excised that from the second schedule, and therefore once that was done, there would have been no need to make any further amendment to the definition in clause 2.
Are we comfortable with that?
In the second schedule,
public place.
Because the second schedule had made reference to public place, and that was too broad, and that is why many operators and retailers had said we are excluding them from, retail sale. And we said that was not the intention, and therefore the committee agreed to propose an amendment that would have addressed that concern, and that is done by taking out the word public place from the second schedule. The issue was not really with the definition of public place in section 2, but it was in the second schedule where it referred to places where smoking would not be allowed. It was going to be too broad. So we took it out of the second schedule.
Okay.
At least that's the proposal from the ministry.
Chairman, reading the second schedule in the bill here, I don't see where what Mr. Edwards is speaking to is addressed, because the second schedule in the bill speaks to health facilities including pharmacies, sports, athletics, and recreational facilities for the use of the public, educational institutions, bus stops, 5 areas designated for use by children. And then I see here in what we have the revised provisions, there's as revised to exclude public space. So I don't see where that is addressed here, because there's no place in that of public space in the original bill, second schedule.
Explain it for me.
If I might, I think we are confusing two different clauses. You raised the issue of clause 19. And clause 19, the concern in clause 19 was that public places should be redefined, and that is dealt with by removing it from clause 19, because clause 19 provides that no person shall sell or offer for sale a tobacco product or relevant product in any of the following places, and within such distance as may be prescribed in relation to such places, including public places. In that clause made it broad. It meant that you couldn't have a business that sold cigarettes, or cigarettes were sold in a certain proximity. So that was to be done. There's a second part of the I think it came out of a submission to us, where there was a concern that there should be a larger penalty for someone who offers for sale tobacco products near educational facilities, near schools. That was a second concern. And I don't know that we have addressed it. I would suspect we would address that in the schedule of penalties. But the issue that we have been discussing now in relation to the second schedule impacts clauses, I believe it's, give me a moment, 12, 13, and 38. So those clauses, Chair, deal with the where a person shall smoke in clause 12. In clause 13, the duty of the owner operator of an enclosed space in terms of the display of no smoking signs, etc. And in 38, it deals with the minister's power to amend the monetary penalties. So we're mixing two things. May it please you.
Then, in relation to
Are you seeing that?
to clause 19.
I'm trying to follow, Chair. Sorry.
Mr. Edwards, it's just that you made a reference to second schedule in the deliberations on clause 19. And my concern was that the public place was not referenced in the original nor in the second schedule there. And I see the point that the colleague Senator is mentioning, that 19 refers to the sale or offer for sale, as opposed to what second schedule is dealing with, is places where smoking or holding liquor or electronic tobacco product or relevant product is prohibited. So having removed public places from clause 19 satisfies the concern that the committee has. But it was only the reference of that second schedule to clause 19 that the concern, as Senator Golding has, Campbell has pointed out, is where the concern was. And she's correct.
Chair, colleague, Member Guy, we still haven't addressed the issue of whether or not we would be minded to increase the penalty where the sale is to children near an educational facility.
No, Chair.
And that's the point I wanted I was making earlier about the penalties, because I do believe that we should. Mr. Edwards, I need you. It's important that you are clear on what is being said, because you're going to have to come produce the final document, not to cause us to go over it again. Are you clear with what has been said?
I'm clear, but I think there's an error in the reference in the second schedule.
Right. That's the point that was being made.
Yes.
That was the point that was being made. So if you are recognizing that, and you are clear, I'm assuming. Do you need to say anything for clarity? Do we need to, for the record?
Chair, I only have one concern, and I don't think we should change the fine, the quantum.
Why?
I know we want to send a message, but $1 million, I think is adequate.
Let me tell you, I hear you, member, and I appreciate the point, but I do believe that for an individual to premeditatedly and, well, obviously deliberately impose through one way or the other a deviant activity on a minor, there should be special recognition of that. Because it's one thing for an adult to make a decision. It's another for a minor, particularly in an institution of care and protection and learning, to be influenced into that kind of habit-forming behavior. As a matter of fact, my view is probably even more radical. It shouldn't be just around an institution. It should be wherever that minor is, that one should be penalized more aggressively for that, because this is a very vulnerable age and an impressionable age. And indeed, today we had a discussion at my office with the Council on Drug Abuse looking at new and emerging threats like Molly and vaping, of course, and so on. And it is a bigger problem than we would like to accept or admit. And the truth is, the purveyors of these substances are very clear in terms of their motive and in terms of the impact and why they are targeting these younger people who are more impressionable and more likely to accept, even on a trial basis, which can then lead to much longer lasting ill effects. So I do believe that we should single out and recognize this kind of abuse and should allow for a commensurate response in terms of sending a message and also the penalties. I don't know what other members think, but Member Golding says she agrees. I don't know if there's anybody else who wants to comment.
I hear you, Minister, Chairman, and I still will maintain what my position is. I don't think it should be increased. So we can agree to disagree on that.
All right. Is it time to discuss that, or should we await later on? Yeah?
I just need some clarity from you, because you had indicated just now that other than the places defined in these areas from A to F,
we could ask, I'm coming to you, member. The question is being asked, did we agree to remove public places from Clause 19, or to provide a definition?
But if you were to provide a definition, you're going to have to expand.
What was the decision, Mr. Edwards? Yes.
Thanks, Chair. I recall in some sittings way prior where we agreed that the insertion or the inclusion of public places in 19 was really an error. And this was the basis for the industry's submission, that to have it there would mean that you're prohibiting sales altogether. So once we remove it, then there's no need to revisit the definition.
Okay. That's right. Okay. So we're removing it then. Mr. Edwards. Sure. Yeah? Okay. All right, you were saying...
Chair, where you had indicated.
Well, I'm assuming that the committee... Maybe I shouldn't assume. Are we agreeing, committee members? Yes, they're agreeing.
Yeah.
Go ahead, member.
Yeah, where you were saying that the sale to minors ought to be for everywhere that minor may be. It might be a challenge to detect it. Say in the home, you might have a difficulty to detect or to investigate such a matter and, to bring it to justice. These areas are areas that can be easily monitored and might be easier for evidence in nature because they are prohibitive. So expanding it outside of that might be difficulty to monitor.
Except that it is a practice, and I know of at least one case where home deliveries are made to minors selling vape and other such material, and using different methods, repackaging, in other words, if someone goes through the trouble of having a telephone ordering system or a text ordering system, and they gas up their vehicle and drive to a resident clandestinely behind the backs of the adults to sell a 13 or 14-year-old vape material, it is clearly deliberate, calculating, and premeditated, knowing full well that the adults in the home would not give permission, clearly, and knowing, or maybe even not knowing, the ill effects that it will cause over time, both in terms of leading to addiction and otherwise. I believe that that kind of behavior should be singled out for special mention and treatment. So I agree with the schools, but I do believe that it could be widened also to minors in general, because you're not going to do that by mistake. You're doing that deliberately. And as a parent, I would not like to see any of my children or any other parent go through that situation where their children is exposed in that way. There are enough risks out there to add to those risks. And it is happening. If you talk to the Council on Drug Abuse, look at the studies that they have done. It is not an outlier. It is happening more frequently than you think. So I would really want us to consider that, to send a signal. Yes?
Yeah, Chair, it's 15 that these will supply to children, not 19. And it is generally worded.
I'm
so
speaking
it's not
about
limited to any facility.
I'm speaking about the penalties.
Yes,
I'm speaking about the penalty.
For 15 is what we should.
Yeah, I'm speaking about the penalty. All right, so can we move on then to 24, which looks at ban on tobacco advertising.
Sorry, Chair, sorry, can we just get the decision then on, is there a decision on 19 of the committee?
To remove the reference to public places in subsection 1, paragraph C to be deleted.
Right.
And the consequential amendment to clause 2. Okay.
Okay. Yes.
Chairman,
we discussed it.
in your discussions when I was talking about the $1 million, wouldn't it be more appropriate to have that for clause 15?
Yes, we just said that.
Yes.
While you were reading, you missed the point I was making.
I can walk on through, Chairman, but I didn't.
We recognize that,
Okay.
and we agree. Okay, so 24, ban on tobacco advertising. Ms. Dennis Wright was to return to the committee with an opinion on issue of prohibition of certain forms of tobacco advertising, promotion, and sponsorship, such as gift-giving, retail incentives, and the retailer incentive and the offering of discounted products. Are you in a position to shed any light on that?
Chair, I was a little bit confused when I saw it as an action item for PAHO, because we did send those opinions and those cases the last time. So, Ms. Brandon, you'd recall that I even raised it with you ahead of this sitting and resubmitted the documents just in case it was missed.
Okay. I'm told that the discussion didn't take place. Mr. Edwards, you have an opinion on 24?
The main concern is in 5, subsection 5 of 24, where the question of the depiction for journalistic, artistic purposes, etc., has prompted us to propose a rewording to hopefully clarify the scope of that provision. So if I may read it, subsection 5, the prohibition of advertising and promotion of tobacco products or relevant products and tobacco sponsorship shall not apply to the following: A, depictions of tobacco products or relevant products or their use in media where the depiction is justified by reasons of historical, and we took out the words purely coincidental, so historical accuracy or legitimate journalistic, artistic, or academic expression. And then we add some language here, or propose to add some language here. And indicative of such a justified circumstance would be a media publication with coincidental tobacco with coincidental tobacco-related content in the background, or the depiction of historical personalities, or a presentation of views on tobacco regulation or policy. And this was with a view to more directly using the language from the FCTC guidelines.
Any comments?
It just sounds to me like that expansion ought really properly to belong in regulations, not in the Principal Act, because it really is sort of giving a better guidance to what we're talking about here. It's unusual, I think, Mr. Edwards, correct me if I'm wrong, to have that in the Principal Act, isn't it?
It's less unusual nowadays.
Yeah, if there's no,
if
it adequately captures the, if it adequately captures the intent and it's accurate, I would split hairs on it. Member.
Sure, you know why I raise the point? Because we've been going through some clauses where we have been adding things that really usually don't go into the Principal Act. They're a function of regulation, subsidiary legislation. And I'm concerned that when we do that, what are we going to be putting in the regulations? And are we mixing the force of the two?
Okay, I hear you. I would have to be advised by the legal minds on that. But I suspect we'll find a way, even if it's repetition, when we get to the other aspects of the legislation. Mr. Edwards, is there another way, or you say it's happening more frequently than in the past?
It is happening more frequently. It is.
There's no objection to violent objection. I think we should proceed. I want to ask a question, though. I know time is running, right? I note in recent times that the tobacco companies have taken out full-page ads in the print media in particular to announce a price increase, for example. So it's a full-page ad that is providing information, clearly, new prices are, but clearly also an opportunity to promote the product. And I wondered if the legislation captures and discourages that kind of activity, if you will. Would what you have there take that into, consideration? Because that has been the latest form of advertising, to my mind. Mr. Edwards?
Could you just repeat the...
I have seen in the print media over the last few months an announcement from the tobacco company, whether it is a price increase announcement, but information to its customers become also a kind of not so subtle attempt at promotion and advertising. Because for starters, it's a full page ad, and after the minor details of what is being announced, you can't miss the branding of a particular, of the company, the entity. Like our new short pack has no XY price, things like that. I just wondered whether or not what we are proposing here deals with that.
It does. It does, Chair. And I would expect that after the law comes into operation, we would not be seeing such type of activity.
All right. Fair enough. Okay, if there are no objections to 24...
Well, Chair, there's another element to 24 that a proviso at the very end, which ties back to the earlier paragraph, which is also highlighted. And so you have A, B, C, D, E, and then it says, however, in no circumstance specified in paragraph A or B, and we had looked at paragraph A earlier, shall there be any evidence that the media insertion or commentary was made wholly or partially for commercial or tobacco industry-related reasons, such as activity involving payment or other provision of benefit for the placement of tobacco products in the insertion or commentary.
Any comments, members? CSG? No comments? Can we accept then? Yes. Okay. All right, so can we move on then to, we just have 3 more quick clauses and then we can close and allow some time for the deliberation over the 2 that we missed earlier. 27, function of authorized officers. Committee to further examine subclause 4. Mr. Edwards, any follow-up on that?
Well, our understanding is that the committee members had wished to consider this matter further. I
suspect it was Senator Golding Campbell. Clause 27, function of authorized officers. Yes. Have members given any further thought to this? If not, if now is the time you're giving thought to it, we could leave it and get back to it at the next sitting, as long as we commit to give some thought.
But Chair, if I may, this is really going to corruption. This language is speaking to anti-corruption, an approach to anti-corruption. I just wanted to say that.
Madam SG, any comments on authorized officers, clause 27? Was that expressed in your memo on July?
No, it wasn't.
It wasn't. So you have no issues with it? Is that an assumption? Safe assumption, that is?
If you don't mind, we'll just look at it again, and if we have an issue, we'll raise it at the next meeting.
So make a note of that for our next sitting, please. Yes,
Chair,
Member Guy.
Our discussion was that the committee will examine subclause 4, and I have noted in my book here what is the penalty for an authorized officer who abuses his authority? Because that is one of the concerns that came up. There's no penalty there, right? And this is where the committee had some concerns with, because
what is the sort of precedent for something like that?
So that's what we're just going to check.
Okay, all right.
It's from what I recall, it is an act of corruption, but it can be an act of corruption under Section 14. There's a long list of acts of corruption in Section 14 of the Corruption Prevention Act, because what we wanted to do was look to see how the language syncs with that in the other act. From what I recall, I think that's $1 million penalty in 1 year, I think. But the offense was not created under 27. There's nothing in 27 to say if you breach the provision, you have committed an offense. No offense has been created.
What I'm going to, go ahead.
If I'm an authorized officer, and it says here that I shall not abuse my authority, then it stands to reason that I must be aware of my scope of permissiveness. What is this abuse of authority? Does it mean that I speak to you in a manner to which you don't like? And am I subject to sanction because I raise my voice at you? I just want to be clear in terms of what it means as an abuse of authority to which I'm going to be subjected to a penalty, and if that can be clearly defined.
Yeah, but
Chair, I suppose one way of looking at it is to ask, if this provision were not here, what difference would it make? Because the truth is, and I think SG may agree, there would be other provisions of law that would govern abuse of authority. So the question is whether the committee wishes to keep the provision, because even if the provision were not here, there would be sanctions for abuse of authority by such an officer.
The fact of the matter is that the provision is clearly here, but not defined in terms of the abuse of authority.
So the question is whether or not we could allow the act or bill to be less complicated by removing it, knowing that there are other legislation that could capture the offense, the breach.
Or we have to go further, Chair, if I may, sorry to interrupt, Chair, go further to just create an offense with a penalty in this act. So it's either we go the full...
I have no difficulty with that, because that's where I started out, where when I spoke about understanding the scope of my permissiveness, if you are going to discipline me on something, then I must know what that discipline is aligned to. But rather than just make a broad statement here.
Yes, member, okay.
I think we need to look at this actually, that this provision, subclause 4. It says further for personal or financial gain. The financial gain, I can understand that part of it. But the personal part, we have to be careful in terms of what it really seeks to address. Because personal gain in a particular situation where the authorized officer may seek to belittle the person who he's having some checks on is a personal gain. I mean, that doesn't need an offense. I mean, sorry, a monetary offense or anything like that. So I think that we need a little more thinking on this one, whether we should have some penalties or we should have some other clause which supports this.
Okay, but I'm going
to agree with me that the personal gain may also mean the number of cases to which I investigate might cause me to get a promotion.
True.
Okay.
Like the police, them nowadays, every young officer have to come in with 15 or 20 infractions every month. Although the commissioner does say so.
Okay, what I'm going to propose, just to be efficient in a discussion, is to ask that for the next sitting, maybe the SG's department and yourself, Mr. Edwards, add to the conversation that I hope will take place between now and then, what may be the most efficient way to handle this. Because I do believe that if you don't have to spend time adding to the bill, the legislation pending, because it is already captured elsewhere, which is a principle that the SG has advanced earlier in the discussion around a number of the earlier clauses that we were to discuss, then that principle could follow through in terms of allowing for some consistency. Unless for whatever reason we need to deviate somewhat in terms of some of the penalties or otherwise, then we may want to deal with it specifically here. So if we don't think we need to, then we allow the other legislation to capture it. If we think it's necessary, based on what is being addressed, then we come with a recommendation, or at least an option. Is that okay? Yes, SG.
Just to say that the Legal Reform Department has to be a part of it because this is more their area as well. And I actually looked, so the penalties in the parish court, first offense is $1 million. This is in Corruption Prevention Act for an act of corruption. $1 million or 2 years or both fine and imprisonment. Second and subsequent offense, $3 million, 3 years. And then in the circuit court, first offense, $5 million, 5 years. Second and subsequent offense, $10 million or imprisonment.
Are those both fine and confined?
Yes, both fine and confined, which would fall into the principle that you have enunciated in both houses of parliament, that if there is some pecuniary advantage that the offender could have, then you do fine and confine. And usually these corruption offenses, most of them, there is usually some pecuniary advantage.
Well, yeah. MP.
Yes, Chair. I just wanted to ask Paho, I've been following the discussion, what has been the experience in other jurisdictions as it pertains to this particular clause with authorized officers?
Yes, thanks for the opportunity to comment on this. This is really a standard provision. In fact, when we even look at the regulations that is currently in place, you'd notice that there is provision made for authorized officers to wear a ministry hat. I recognize even back then that this provision made it clear to public health inspectors, for instance, that there were certain obligations on their part. So if we were to remove it altogether, then, you're sending them to interpret maybe another piece of legislation jointly with this. I think the suggestion that Mr. Edwards made in relation to placing the particular penalty is really what we would need, as long as that is carefully crafted. But to remove it altogether, I'm not sure we will be able to achieve what we want in terms of making it clear and in terms of ensuring that there is effective enforcement.
So, if I'm understanding you clearly, you're saying that the preferred option should be to keep it in and to be more specific around the penalties.
Yes, Minister.
If that is
certainly.
the case, then what we may need to look at then are what those penalties should be, right?
Right.
And maybe we need to look at that then as the option if nobody has any objection. Let me hear you.
So just to say, you would also need to look at the wording of the provision you have. So acts of corruption are very specifically crafted because they're also international obligations. So when we did the Corruption Prevention Act, we didn't just do it because Jamaica thought, we have a problem with corruption. We were actually implementing international obligations, and it's consistently the terminologies, the way we have crafted our acts of corruption, you will see them in other jurisdictions. So we would have to be careful about the wording that is here. And I would say especially because we don't want to be looking as if you're creating your own sort of act of corruption that does not fall in line with what's internationally or with the Corruption Prevention Act.
I'm with you, and that is exactly why you're going to meet with Mr. Edwards to assist us in that wording, which we will appreciate a lot. But I take the point, which is why I said, if you have existing legislation, you have to ensure that you conform in substance and in optics, I guess, with an intent with the legislation. Right, Mr. Edwards? It sounds as if you and the SG and the Legal and Constitutional Reform Ministry have some interaction to do. Okay? Yes.
Chair, can I just say, I think we're delaying ourselves unnecessarily on this point, and let me tell you why I say that. Because Section 14 of the Corruption Prevention Act, which has quite a number of subsections, which deal with all kinds of ways in which public servants can find themselves charged with an offense for corruption, whether you're soliciting, whether you're using for your benefit, and it has very specific language. I find this provision, with all due respect, abusing your authority for personal or financial gain, quite useless in law, because it requires you to interpret too many things. I'm going to say loudly as I can, I don't support the inclusion of it in this. I don't think it adds to it. I think it obfuscates it, and I think it ought to be removed, and we rely on the very well drafted and tested provisions in the Corruption Prevention Act, which are more than adequate to cover this issue.
Okay. That is very forcefully made. But we do have a difference of opinion because on one hand you have the established sort of global protocol. I suspect that's what was articulated on by Ms. Dennis, and on the other with justification, is the argument to rely on the kind of mother legislation around corruption. My approach would be to be as efficient as we can in terms of achieving the final document,
Chair.
but also at the same time achieve the clarity around the provision or the intent in terms of the offense.
Chair.
So the question is whether or not we achieve both, going one way or the other. I'm going to ask Ms. Dennis to come in. Let me, okay, go ahead, Dr.
You
Dennis.
know, Chair, you have adopted an approach from the start of the meeting which has served us well. And I think the approach is...
An approach that you admire?
That's served us well. That has served us well. And which is to ask the SG in situations such as these, what is the view? And I see you have moved away from that in this last one here. And I would respectfully ask that you resume that particular aspect as it relates to this final one here.
Okay, so you have lost the admiration. All right. I wasn't going to come down one way or the other on the decision. You know what I had wanted the PAHO perspective through Ms. Dennis, but I still was going to allow a discussion between the SG and Mr. Edwards and maybe the legal and constitutional unit to come up with a recommendation for the next sitting. Ms. Dennis, you wanted to make a final point?
Yes, Minister. I wanted to clarify that the position that we gave just now was not specifically in relation to this subclause 4 regarding the global, what we can, or what we have seen globally regarding this specific provision that says an unauthorized officer shall not abuse his authority. The position that I was making, or the point that I was making earlier, was really that in respect of references to authorized officers and provisions treating with authorized officers generally to carry out their functions are really standard, and one such reference can be found in the existing regulation. So not in particular to the abuse of authority.
Okay, point taken. So we'll leave that then for the next sitting with our recommendation, but I think some clarity has been brought to the issue. Can I move on to clause 38? And we'll try and just maybe suspend that clause 38 for the day. So clause 38 speaks to the power of the minister to increase monetary penalty and amend schedules by order. Discussions had whether the minister should have the power to amend second schedule. Currently worded, second schedule is excluded. Pointed out that by the LRD that consideration should be made on whether it is intended that clause 12 should obtain a general power to allow to minister to expand facilities set out in second schedule. Any further thought on that, Mr. Edwards or SG?
It's just a consequential amendment, Chair, that if it's a question of policy. If the committee wishes to empower the minister to have the power to make changes in the places where smoking should not occur, a second schedule. And if the committee is minded to give the minister that power, then the amendment proposed would stand. So once the committee is desirous to give the minister the power to modify.
Members, what are we? Have we given any further thought to this?
Chair, I don't see a problem here. The fact that it has to be subject to affirmative resolution. And it is this very said members who are sitting on this committee who will either do it or not. If it's just a negative resolution, that's another matter. But it's an affirmative resolution. It has to be tabled, discussed, and then give that authority. So I don't foresee that this is a problem here.
Is that a general agreed position?
Share that view. Today we're making this legislation.
I don't hear Member Golden Campbell, so she's supportive, and the others? Affirmative, okay. I'm told now that if that is the case, we may have to amend B to include the second schedule, Mr. Edwards?
B would now just refer to the schedules because it will be a general power to amend. It will include all schedules, so we don't need to refer to any particular schedule. Chair.
All right, so there we have it, and members. So let me just do a brief wrap-up on where we are. So I think we have to return to 7, 8, 9, and 27 based on what, and then the second schedule. And then we go to interpretation, clause 2. Is that agreed by all? We have made some progress on 15, 19, 24, and 38. So the meeting was worthwhile. Yes, Mr. Edwards.
Chair, I believe, and I'm going to ask SG if I'm quoting her correctly, but earlier in the meeting, a comment was made, I believe it was the SG, that there's only so much that we as the advisors or the technocrats can do in terms of advising on proposals. Is that so, SG? I hope I'm not
yes,
rephrasing.
It was in respect of a very specific matter, though, yes.
Yes. And
if I may, sorry to interrupt you. I am not asking the deliberations to lead to a recommendation, except that if that were the case, then we will consider it. Ultimately, the agreed position has to be taken at this level. What I want is consultation. And what I heard in the first instance is that there was insufficient time given for consultation to take place. So I'm asking, which after 2 months, I was hoping that would have been possible. So I'm asking that a conversation be had over the next week or so. And I'm asking kindly that the SG's office and yourself, and if necessary, the legal and constitutional team meet, whether virtually or otherwise, go through the 4 clauses, and if there is a deadlock or there is no agreed recommendation, just come to the table and say why there is no agreed position and then allow us to make the decision. You understand what I'm saying? So you have sent a document to SG. SG needs time to review. Hopefully she can, or her unit can, over the coming days, and then we try and wrap this up in time for our next meeting, which we will probably allow for 2 weeks or so to get back. And well, we have a meeting next week, but I don't want to come here and get back into the same situation. So I want to ask SG, is there time to try and go through these 4 or 5 clauses to at least have some sort of consensus either on an agreed position or not?
So when you talk about, well, it's the AG's office and the team, this is a team. So the unit, it's me and Ashley Marie. We'll have to just try and work with what you have said, Chair. The only issue is, as it relates to being able to properly advise on those troublesome clauses, the cases, unless Mr. Edwards can give us some sort of summary or so of some of those cases. Some of them are huge, and we also have other matters to deal with as well. Unless Mr. Edwards would also like to bring in the legal reform department, because that would greatly assist in a review, because really 6 minds are better than 3/4. Miss Alden, I make a 3/4.
I'll never ascribe a 3/4 mind to you, SG, and you shouldn't to yourself either. It's a disservice. But Mr. Edwards, can you try to assist?
Well, Chair, if I may, the original team we worked with included the legal reform, which is part of constitutional, and Legal Affairs, and the Office of Parliamentary Counsel, of course, the Attorney General's Chambers. So it was all of these departments.
So what I'm saying, colleagues, I really want to get this finished at the next sitting.
Chair.
Get to the point where we can go through. If there's any delay, it probably would be interpretation, clause 2. But I really want to move the thing through and get it over and done with so that we can prepare. So I really would like the pre-meeting to take place and that there's a considered discussion so that, Ms. Edwards, you can keep in touch with me outside of this forum, of course, where I can accommodate or support, I will. Huh?
Chair.
It's a week away, which is why I'm asking, do you need more than the week? If you need 2, then we set a date for the week after.
Chair, which is the same point I was making, because you asked a question, it wasn't answered. What was answered was that the cooperation will be there. What we need to know, can this be accomplished within a week for our meeting next week? I
am prepared to push back for a week if you need that time. I don't want to not have it done, though. That's the thing.
Maybe Chair, a week is definitely not enough.
A week is not enough?
No, sir.
Okay. So can we then agree to 2 weeks or the next available date after week 2? I'm being advised that maybe the 15th would be an available day, but I think that's out for you, and it may be out for me too. The 15th, yeah. No, that's a Thursday. Any other? 29th. No, I won't be here. All right. Maybe we need to circulate a date and time. Can we circulate a? Because I don't think it's gonna. Because it. Yes, I don't. If it would have to be maybe the first week in October. That's a 1 month delay, but. Because I am not going to be, well, some members may be traveling on official business, and then there are other
Chairman,
issues.
We have always had a problem with the use of this area here. Have we ever considered, considering the availability of support staff, having the meeting elsewhere so that competing engagements in the Parliament, building itself here in the chamber, will not affect us? Other committees have met elsewhere that the Parliament pays for us to meet. Isn't that something that we could consider? Because if we are, each time we are to set a meeting, it's dependent on the availability of the chamber. Is it that staff is available so we could meet elsewhere?
Yeah, so what I'm being told is that the issue is not just the physical venue, but the support staff. So once the place is booked, it's the same staff that has to tend to the activities. So that's a challenge. If the committee can't turn around this within the next week, we may have to push back into early October, unfortunately. So I'm gonna ask for the dates to be sent out, and then we try to accommodate as best as possible. Maybe right? So members. All right, is that agreed? That's agreed. So. And the dates are going very fast. Well, my office will give you a date tomorrow, so you can circulate. Are there any other business?
Chair?
Yes.
So just a technical point. In terms of the preparation of the report of the committee, what is the, where would we be at now in terms of preparing the draft of the report? Because these are really, what we're discussing are appendices to the report in terms of the provisions and the proposed text of the provisions. But it would seem as if 80–90% of the decisions have been made already by the committee. Where are we in terms of the preparation of the report and in terms of what is reasonable for the staff, of course?
So you're inquiring about the report itself?
Yes, Chair, because you see what we are doing now, if let's say at the next meeting, all the decisions are taken in terms of the clauses, is it at that point that the report is going to begin preparation?
I suspect so, given... Huh? I hear it's being worked on, but I hear it's being delayed by some of the delays that are taking place in this house, Mr. Edwards.
Okay.
I'm not pointing at you, but you know you have a big role to play in the completion of the process. So we need to move the process forward and put the pressure where it needs to be at this point in time. As soon as everything is finished, I'm going to pressure the house to provide a report, and they know that. Right now, we just need to finish up. So I'm hoping that the discussions with yourself and the other committees take place as quickly as possible. All right, if there is no other business, I just want to say that we are going to attempt to have a final session, all being well, for this aspect of the bill, and then we move to report. I really would like to see us table the bill in the Parliament or for debate, or get to the stage of debate this side of the calendar year. It's very important. I also note in closing that increasingly, and I suspect it will happen more so closer to the discussions in the Parliament, that we've seen some items in the media around the impact of the legislation on, you know, organizations and individuals, and the cases increasingly being tried in the public square. And I suspect, among other things or reasons, it is to influence public opinion in one way or the other. You know, we are mindful of that, certainly in public health, Ministry of Health and Wellness, we are, and we will respond to those where we need to, but it underscores the need for us to quickly get to the Parliament and have the serious conversation where the conversation ought to be had, because this is not something that, you know, public perception alone is not sufficient to determine what the public's good represents. And some of the conversation, I think, is intended to influence public perception without sufficient sensitivities and consideration for the public good. And that's the mandate of this committee. So let's try and keep focus on that mandate, and where we can realign the public's expectations on what we are doing, why we're doing it, and why it is important for all. All right, if there's no other business, I move for an adjournment until notice of the next meeting. Moved by Senator Gale, seconded by Senator MP Wilson. Taking you out of your seat, sorry. Meeting adjourned. Thank you very much to all who came.
something is happening for someone in this country every single day as a result.